Hey, I'm Kristen Dama. I'm the managing attorney of the SSI practice at Community Legal Services. I know I've met some of you before, so it's nice to see you. And for those who are new, it's nice to meet you for the first time. With me is Sara Lynch, who's an attorney at CLS. She runs our applications practice, so she is a font of knowledge about that, but also about SSI in general. And so we are really excited to join you for what is either going to be a refresher or a new introduction to SSI practice. It's going to be a three-part training. So I'm just like making sure I can advance my slides. So we're going to start with just a really basic overview of what SSI is. Then we're going to run through the 5-step process to evaluate an adult, or by which Social Security evaluates an adult SSI case, and that we have to kind of run through in our practice by extension. And then Sara is going to spend some time talking about the actual, like, how to practice in an SSI case and what that looks like. So this is a great, as I said, if you are a sometime practitioner or a never practitioner or a law student intern, or maybe you just like feel like you want to brush up on your vocabulary, that's really what this is intended to do, is to just kind of reintroduce or introduce some basic concepts, give you a ground, a basis for SSI practice, whether it's as part of your summer internship or part of, maybe a growing part of your legal services practice. I think, are thinking this is going to be about, the full 90 minutes. Each section, we're thinking it'll be about, we're going to try to stick to 20-25 minutes and then pause for questions about that section. Although, of course, you can ask about preceding sections too. So if you have questions that pop up, please add them to the chat. I will pause and Sara will pause after each section just to like answer anything that's arisen or make any quick clarifications. If there's stuff that just feels really unclear that you cannot wait, Sara and I will keep an eye on the chat and try to answer as we go. But I think the goal is to kind of pause and do like a formal Q&A, and not just at the end. So hopefully that kind of helps you plan with any questions that might arise for you. All right, with no further ado, let's just talk a little bit about SSI. Sorry, I'm still working on making my slides aren't quite advancing on SSI and like what it even is. So if you are a brand new practitioner in the Social Security world, I think it's really important to know that the governing legislation around SSI is the Social Security Act. And there are a bunch of things in the Social Security Act, including Medicaid and Medicare and lots of other things that don't quite touch on the work that we're doing today. But there are 2 titles within the Act that govern our work. One is called Title 16. That is where SSI lives, the law around SSI practice. And then Title 2 is, and I keep meaning to change this, is OASDI, old age survivors and disability income. And for like purposes of like the plan Social Security disability practice, we're really focused on the SSDI part. That's the Social Security part that you get for disability benefits. When most people think of Social Security benefits, what they're thinking about is Title II. That's the benefit where, a chunk of money from every paycheck gets taken out, sent to Social Security. Every once in a while, you'll get a statement that says you worked this many quarters, and if you become disabled or retire, this is how much you'll get each month at this age or this age or this age. That's sort of kind of the Social Security that everybody knows about. SSI is a cousin program to that. It's for people who haven't had that money taken out of their paycheck, and you can qualify based on little or no lifetime earnings. Just like Social Security, based on your age. For SSI, it's at age 65, or disability. And the disability standard is the same. What's really different are those income rules and those eligibility rules, because SSDI is, you have to have a certain number of quarters in a year that you pay into the system, and then they look at your last 40 quarters when they're calculating your income. SSI is a flat benefit for people who haven't paid into the system enough, or maybe at all, for various reasons that we'll talk about. And so it really is sort of a safety net benefit, and one of the only cash assistance safety net benefits that exists in this country. As I said, the Social Security Act also has Medicare, which is different than Medicaid. Medicaid is benefits. It's a federal state partnership. Those are benefits that are administered by the welfare office. Medicare are benefits that usually go alongside OASDI benefits, old age and survivors benefit, or disability benefits generally. That is, as I said, administered by the Social Security Administration, totally outside the scope of our training, just to sort of acknowledge how all these different pieces fit together. So as I said, SSI is a federal need-based program for people who have not paid into the system for a bunch of reasons. It may be because they're a child, it may be because they're an asylee or a refugee, it may be because they have lifelong disabilities that have precluded work, whether they have been diagnosed or not. It may be a lot of other factors, right? People have complicated lives, but it is intended to be a cash grant for people who are either at retirement age at age 65 or have these serious long-term disabilities. As I said, the people who get them are largely, you have to either be an older adult, age 65 and older, as I said, or you have to be an adult with a serious or long-term disability, or a child with a serious, severe, and marked impairment. And we are not going to talk about children's benefits today. Just know that they exist. The rules are slightly different in that they don't include work. Instead, it really focuses on a combination of impairment, like a disability diagnosis, and then how that disability affects your ability to your development in a way that looks at kids without that same disability. For adults, it's a very work-based system, right? It's an interesting benefit because it is for people who have not much work history for a range of reasons. But the focus really is on how the disability affects ability to work. And so disability on its own is not enough without that sort of worker lens. And, you know, I could give you a whole talk about what it says about us as a society that people's eligibility or people's ability to get help is somewhat tied to their ability to work and societal values. I feel like there's a very interesting conversation to have. I'm not going to do it. I'm going to mind our time, but it is sort of an interesting and sometimes startling thing for people who are new, is that that your eligibility for this benefit is totally tied up in how we view your utility as a worker. So if you look at the definition, you know, it says the formal definition is here. Inability to engage in substantial gainful activity because of mental or physical impairment that's expected to last 12 months or longer or result in death. And so, you know, if those of you who are in law school, you know, you've been kind of taught how to unpack these definitions and break them down. And you'll see when we get into the kind of nuts and bolts of how these cases work, that there's several pieces. There's ability to engage in substantial gainful activity, which we'll talk about in a minute. The actual impairment, which is mental or physical or a combination. And then the big piece to just flag is there is a durational requirement. So sometimes we get calls, and I'm sure some of you all have got them as well, where somebody's like broken, you know, their arm or multiple arms, or they're in traction from a car accident. If those disabilities are not going to run, if the resulting impairment, the resulting inability to work is not going to last for 12 months or longer, and really they're looking at something that looks like long-term, right? Like having a doctor say 12 months plus a day is not enough, right? We're really looking at something that is a long-term sustained disability that's going to keep you out of the workforce for a big chunk of time. Then that is that is also a requirement. The flip side, or death, we see that a lot in like metastatic cancers, where people have so many months to live, for example, where it's not, you know, if you have 5 months to live, right? Like that's not a 12-month impairment, but obviously that is work preclusive. Metastatic cancer is a fairly clear-cut eligibility pathway. And so, you know, that's to make sure that people who have a shorter time to live beyond less than the 12 months can qualify easily, that they're not going to get tripped up on practical or technicalities. So the big pieces, and I'm going to talk about this a little bit in the 5-step piece, but I just want to say, SSI, nobody on this planet gets rich on SSI, right? As much as there is, and thankfully this has died down every once in a while, there's, Congress and, think tanks decide they want to beat up on people who get SSI benefits, even though they're incredibly hard to qualify for, and really not well below the poverty line. And so to just be really clear, they are below sub-poverty benefits. Most people on SSI get either $794 or less because of other income in their house or because of overpayments. The actual benefit is usually less than $600. The maximum benefit for people who don't have other income or other sources of support or anything like that, they're getting $794 plus a little bit of a supplement from the state, a $22.10 payment. Those payments, just to say, because sometimes we get questions about those, are paid the same way. So if you get a direct deposit in a bank account, then that $22 goes in your bank account too. If you have a direct express Social Security debit card, you get the $22 on the debit card. So a lot of people don't fully realize that they're getting that $22 separate, because you get paid on the first of the month, the money shows up then, and it kind of commingles into whatever payment source that you get. There's also an asset limit, $2,000 for single adults, $3,000 for couples. Again, there is no way to become wealthy or, on SSI, and it's an incredibly difficult thing to acquire. It's much easier to work, right? And so this is really a program for people who can't. And if they raise their hand in general, that they're agreeing to a very restrictive economic status, and so to just sort of push back against any framing that you have heard otherwise about the SSI program. The other thing I'll just say about this, just to flag for folks, is that there is some work in Congress this year on the SSI Restoration Act, which is super exciting, that would raise the SSI benefit up to the poverty level. It would make married couples, you can see here, a household of 2 married couples get $1,191. It would basically be a double benefit, right? There's no offset for a married couple. Each person in the married household would get $794. So it would end the marriage penalty. It would dramatically increase asset limits. It's super, super exciting. Jonathan Stein's on this call. He's doing a lot of work and has an email. Maybe Jonathan can send out, maybe John can send out to our plan community about ways, even if you're an LSC program, to point out the need to have a higher, a more generous SSI program that don't run afoul of LSC restrictions, like social media, or just educating folks about how important SSI is and how hard it is to live on $794 a month. It's really, after years, again, as I said, of SSI recipients being sort of beat up in Congress and in the press, there's polling that shows that SSI is actually just like enormously popular across both major political parties, and it's just really, really exciting to see the discourse and the policy start to catch up with the fact that people believe that SSI is good policy and that it's something that people should get if they need it. So that's my little soapbox plug, and Jonathan or I will send around more information if you're interested, including, again, how to not be violative of the LSC restrictions later today. So to get SSI, you go to the Social Security office, which is hard right now because, the Social Security offices are not open. To get Social Security in general, that's generally the application mechanism, is that you have to go to the Social Security office, start an application, and go through an interview process. With the Social Security office is closed right now. Applications are down between 30 and 40% because it's hard for people to access the systems. Places, people like Sara, lots of social service organizations, probably some of your programs are doing application assistance, even though we can barely scratch the surface of the need. Social Security is doing a lot of work of outreach to try to help social service providers do applications. There's a telephone process. You can download the application. There's a lot to be said about how to do applications, but we are really gearing up for offices to reopen later this summer is the plan, kind of dependent on what's happening with variants and different surges and all of that in July, I guess. But I think we are going to see a big influx of applications. Once an application is taken, the case is sent to a Pennsylvania agency that contracts with Social Security called the Bureau of Disability Determination. That's part of the Pennsylvania Department of Labor and Industry. The only reason it's a state agency is because Social Security would rather pay state salaries than federal salaries, because state salaries are cheaper. That's literally, and have a smaller government. But it's really kind of a quasi Social Security entity within Pennsylvania government, and your clients are going to get mail from BDD, which is very confusing. Before I practiced in this area, I always found that extremely confusing. BDD makes a decision around your eligibility, and then people have 65 days to appeal and request reconsideration. This is a process for those of you who've been in legal services for a long time. This is different than it used to be. Pennsylvania in 2019 was required by Social Security after 20 years of a pilot to reintroduce a second level review, which is basically the application goes back to the exact same office, back to BDD, although to a different person, and they give it a second look. And about 10 to 20% of cases are approved on that second look. And then if you are denied that last time, then you appeal and you go and you have a hearing with the judge at a Social Security Office of Hearing Operations. And then you get a decision, and then there are 2 appellate levels. And we've done trainings on that, and we will in the future. I'm not going to go too far into this, but this is the process that people run through. So it's a long process. 2/3 of people get denied the first time they apply. Only 10 or 20% of people win on recon. 40 to 45% of people win at hearings. So if you kind of make it through this miserable process, lots and lots of people win at the end of it, but this system is really set up to sort of discourage people and have them drop out. And so one of our big jobs as legal services providers is to cheerlead, right? And have people kind of hold on to the extent that they are willing to, that really, if they can make it through the process, like there's a very good chance that they may be found eligible, but lots and lots of people give up along the way. The one thing I want to say is, there is the 65-day deadline. Social Security, because of COVID, is giving extremely generous good cause. And so if you do have people that you're working with that have missed the 65-day deadline, even if they've missed it by several months, and the reason they missed it is because of something COVID related, mail, don't know how to appeal, tried to call and couldn't get any help, lots and lots of things, like had COVID, had a kid with COVID, was homeschooling and just could not deal because they were trying to keep their kid on Zoom. Any of those reasons are sufficient to get good cause. And so please, at this moment, when so many people aren't even to make their way in the door, if you have somebody who hasn't figured out how to appeal, please help them appeal, and they can get good cause and kind of keep going to the end of this process when, as I said, more people do get approved. 2 other broad things, and then I'll pause and answer questions. Once you're on, you're not on for life. You have what are called continuing disability reviews, anywhere from every 1 to every 7 years. It depends on your type of your impairment and how Social Security has classified your likelihood of improvement. Children are also always evaluated when they reach the age 18. If you are reevaluated and you receive a notice that's ceasing you, that's a cessation notice, you have 15 days to appeal. Sorry, I don't know if you can hear the airplane going overhead. You have 15 days to appeal and continue to get benefits pending, the reconsideration process, and then the hearing before a judge. Again, Social Security is being very, very permissive with those appeal deadlines. So if you have clients who come to you and they haven't figured out how to appeal within 15 days because the offices are closed, you can absolutely help them make the election for statutory benefits continuation, or to keep benefits pending a hearing and get them reinstated in pay status at this moment. So please do help your clients take advantage of that flexibility, or at least know that that flexibility is there and they should be raising their hand and asking for it. The other thing I just want to say is that there is no requirement that you have a telephonic hearing right now. So right now, hearings are being conducted by phone or in certain cases by Microsoft Teams, which is kind of like this, kind of like Zoom, claimants have the ability to wait for an in-person hearing. So if you do see somebody who has a CDR or an age 18 case, a cessation case, definitely, if you can, practice tip, use you or somebody that you're practicing with who may be an expert in your organization, make sure that they get back in the statute, get good cause for getting back into pay status, and then they can put their case on hold and not have to worry about being ceased while they're being cut off, while their SSI, while we're still in this weird remote era. We are waiting to find out when in-person hearings are resumed. We have been told by Social Security yesterday that they don't know. So stay tuned. We expect to get more information in the coming weeks. I'm going to pause. I have just a few minutes. I don't see anything in the chat. If anybody has any questions, now's a great time to ask them about anything I just said. And then in a minute or two, we will move on to kind of running through the nuts and bolts of what an SSI case even is.
Kristen, this is Kelly. I'm going to go ahead and launch the first of the CLE poll boxes. Attorneys, you must respond to this first question and then the second one later on, and I will leave this up for 2 minutes. Thank you.
Michael, just checking, I see your camera's on. Did you have a question that you wanted to ask?
Yeah, if I can do it without taking 10 minutes.
Sure, go for it.
I'm going to try.
Okay.
We have a client who was receiving benefits and whose benefits were suspended at the end of last year. We haven't been able to figure out the facts. We started maybe a month ago with the client. He's got nothing in writing except for the suspension of benefits. Our information from him is he immediately appealed, and he appealed because he was informed at the time of the suspension that if he appealed within, and now I forget whether it's 10 or 15 days, his benefits would continue. But Social Security says it got nothing from him. He then submitted something else, says he was told that all he had to do was explain that he really did submit something and that would be good cause. In our first interaction with SSA, we had an hour-long phone call back and forth among a number of people, and eventually we were told at the end of the call that Social Security had already determined that there was no good cause, and his only remedy was to contact a congressional representative or to start anew. And we've been trying to get documents that show, anything from Social Security that shows what happened. We haven't, and we're trying to figure out whether, we should appeal at this point or file a new application. And there's ramifications, risks for both.
Okay, so can I just reflect back what I think you're saying? Because I think this is a really good kind of example of the kind of things that people are running into right now in COVID. So the issue is that he filed an appeal. They lost timely. They lost it. They have said that they're not going to treat it as a timely appeal despite subsequent appeals because they are finding no good cause. And they basically are not willing to engage with you any further. Is that sort of where you are?
Yes.
Okay, so I think the thing that I would say, and we just had a conversation, so CLS convenes a work group with Social Security, and they are investing in a liaison system for applications, and they got an earful from me and from my colleague Jonathan on this call and from others from across the country about how exactly this kind of thing, Michael, like that, and everyone, that Social Security, it's great to have liaisons and applications, but we also need fixers for exactly this kind of stuff when our clients are filing appeal, and there is no luck. I would say, I don't know if you have entered your appearance. I would make sure you have a 1696 in the six, an appointment of authorized representation. And
Yeah,
I
we
would do
did that.
another appeal.
Okay.
And we were told yesterday, and I will say that CLS is not doing this super aggressively. It sounds like other organizations like our friends in Boston are calling them constantly. There's a regional communications person who is the regional ombuds person, and they are supposed to fix these cases when we call them. And so I feel like you should do it. You should call the regional ombuds person. And Sarah, maybe if you don't mind putting that in the chat, the regional phone number for this, for the communications director. And so, Michael, I do the appeal. I would put in your 1696. If they are not, and I would, explain, whatever explanation that you want to do. And if they do not have him open within the week, I would go to the regional ombuds person. But first I'd create that paper trail, sort of summarizing all of the work that you've done, because this is nonsense. And this is exactly what these really good emergency messages from Social Security. So I don't know if you can put your hands on these. If not, maybe we can send them around afterward. There are really great emergency messages that basically say good cause is supposed to be granted, like no questions asked right now. And it doesn't even sound like your guy needs good cause. It sounds like they screwed up and he appealed timely. But Social Security, your field office is not following the law, basically. And so you have every right to push on this. I would not have him reapply, I would not have him give up any rights. I would breathe fire and get him back on.
Okay. And yeah, we did submit a 1696, but it does us no good in the sense that we can't access anything at the moment.
Yeah, I mean, what it'll do is it'll let you go to the regional ombuds person, right? Like that's
okay. Okay.
That's why I'm glad you have the 1696, especially because it takes a minute to have those get up. But if you have that 1696 in, I would do an I-appeal if they say they can't find it, so that you have, which is an online appeal, so that it is crystal clear that the appeal is pending. And then if they are not going to give him good cause for that I-appeal, I would go to regional and have them open it. And honestly, if you can't get regional to open it, email me and I will go to national and we'll reach out to them and have them fix it.
Okay, thank you.
Yep, you're very welcome. All right, let's talk about 5-step sequential evaluations. These are, this is kind of a lot of words to say that when you apply for SSI, there is a 5-step process that they go through. And I'm going to run through each of the 5 steps. First, I want to show you my chart, and I'm very proud of the graphics. I have no idea how I did this, and we'll probably never be able to do it again, but I do make everyone ooh and ah every time I do this training. So please admire my chart. The 5 steps are pretty straightforward. The one thing that's a little confusing about them is the if-then logic is sometimes you proceed and sometimes you don't. And so it's not perfect. It's not a perfect flow chart. The first question is about work, which we'll talk about in a second. If somebody is working, then they don't go any further. So that there is this threshold test, and I'll talk to you about what that is in a second. Otherwise, if somebody isn't working much, you go to the second step, which is, do they have a severe impairment, which has to do with their diagnosis. If they have a diagnosis, then you move on to the third step, which is where a lot of the work is, which is around the listings of impairments, which is sort of a dictionary of disability. And we'll talk about that in a moment as well. You can win at step 3. Not a lot of people do win at step 3, but you can win at step 3. And if you can win at step 3, that's great. Then you don't have to keep going. Most people have to move on to step 4 and step 5, which is that work test that we were talking about. And we will get to that in just a moment. So that's sort of the basic. Let's kind of drill down, because I just said a lot of words that I realize are like a little vague. So let's be a little more concrete. So as I said, that first step is, are you, sorry, I have the poll up and I'm just trying to take it down. All right. The first step is, are you engaging in substantial gainful activity? That's the level of work that someone can do. It is not a sophisticated hour or caliber test. It was literally, are you making $1,310 gross every month? And if the answer is yes, you just do not go on. Social Security just like facially rejects your case. There's no like, but it's 1310, but it's just barely 1310. Like it's a bright line rule. It goes up a little bit every year. If you're making over 1310, you don't get to go forward. If you're working under 1310, you do get to go forward. That's all. For those of you who are engaged in any way whatsoever on case acceptance, I will just say to you that, if you are making $1,309 a month, congratulations, you get to move forward. I would not take, I do our case acceptance at CLS. I would not take a $1,309 case because it's going to be really hard to prove to Social Security that you can't earn 1310, right? Like your case is going to go forward, but it's not going to be very successful because anybody who's making a decision is going to be like, but for 10 more minutes of work, you are working enough to not qualify, right? And so it's just not a strong case. It's not a great use of legal services resources. So I do think that it gets harder and harder to win at the later stages, the closer you get to 1310. You do see people who are working 10 hours a week and they're making, maybe $10 an hour. So, maybe $400, $500 a month gross. And that's just the best they can do. And they have a very compelling story about why that is and why it's only 10 hours. They have to nap after every work day, every 2-hour shift, whatever the story is. And that I think is fine. I think that those cases are, hard to win because why 10 hours? Why not, 25? And that's a story that you have to tell adjudicators throughout the course of the case. But I think that's a story that can be told, right? But somebody who's making 1300 and not 1310, again, I don't know that that's the best legal services case to take. After you've sort of passed this flat test, 1310 or not 1310, right? And you're at 1300 or you're at 100 or you're at 0 in earned income, then Social Security moves you along and you look at whether or not you have a severe impairment. And it has to be a diagnosis from an acceptable medical source, which is basically you have to have a physician, a physician's assistant, basically someone with prescriptive authority, somebody who can write a prescription. So not a therapist or a psychotherapist, not a nurse, not your family member who keeps telling you you have anxiety or depression, you can't self-diagnose because your symptoms look a certain way, no WebMD, right? None of that is okay. It has to be on a piece of paper somewhere in your medical records that someone has diagnosed you with an actual, disability using under their medical license or their practitioner's license. Even some diagnoses are very, very complicated. And we're going to be doing a training, I believe, sometime in the fall that focuses on some of these complex diagnoses. They include obesity. Fibromyalgia is really hard because it's a cluster of symptoms and a syndrome, and there's guidance that makes it actually difficult. Chronic pain, and people have a really hard time with. Richard Weishaupt from CLS did training on long COVID. That's very much an emerging diagnosis. You cannot qualify, I think I said, on drug addiction and alcoholism, although that can be a factor in cases in certain ways, and we're going to train on that. One thing we see a lot in the mental health context in particular is rule out diagnosis, where it'll say R/O ADHD or something like that, which is basically we test them for everything, and if not, I guess they'll be this by default. Social Security just has a really hard time with rule out diagnoses because those aren't definitive, and the murkiness of the medical world does not perfectly match up with sort of the rigidity of the Social Security world. And so those are situations, as I said, we're going to do some training on, but just to say, not all diagnoses in Social Security world are created equally. And so if you do have people coming in just with rule out mental health diagnoses, that case is probably not ripe for you to take, pending, unless they are having evaluations that are going to result in a more concrete, stable diagnosis. Once you have sort of, so again, you're looking at like, you're not working that much, you have formal diagnoses. Then the next step is to compare whatever your diagnoses have and the symptoms that as they manifest based on your medical records. And they look at the listings of impairment. And the listings of impairments are basically, you can Google them. You can Google them right now if you'd like. If not, there's a hyperlink and we'll be sending this around. But it's basically just a list of criteria to qualify with various diagnoses. So there's 14 body systems like neurological, mental, immune, musculoskeletal, digestive. And you basically look up your diagnosis within each of the appropriate body system, and you compare the medical evidence that you have to the criteria that Social Security is using to make your case. In legal services, some of the hardest cases to win, and I know the cases that most of our programs prioritize are these mental health cases. And in the mental health cases, they look like there's a very particular way that these look. Not many people win this way, not because of eligibility or not because their diagnoses aren't serious, as we all know, but because these are very rigid criteria. And they are criteria that assume detailed, comprehensive medical records in a way that does not exactly match up with how mental health providers, particularly in the Medicaid system, provide care. And so to qualify, I'm going to just kind of walk you through an example using trauma, which is one of the more recent mental health diagnoses and one that I'm assuming that your practices see a lot. We certainly see a ton of trauma cases and prioritize them because we don't think Social Security really understands them. They include an A criteria, the medical documentation, which is medical documentation. And then in general, we look at the B criteria, which is functioning. And I'll talk to you about what the C criteria is in a second. But again, we have these A criteria, the medical documentation of symptoms, and then the B criteria is like how it affects how you function. So let's kind of walk through trauma. So the big piece I want to flag for you is, and this is something that I messed up when I started practicing, I know all kinds of new practitioners do, is that the documentation has to be medical. So going back to that diagnosis stuff that I was just saying to you, it has to include a diagnosis, like medical evidence from a psychiatrist in particular, or a school psychologist. Those are considered medical evidence or therapy records. So anything a therapist writes for the A criteria does not matter. It does not count. And so you're looking at basically like, if you have, our clients are in Medicaid systems, they have to have an eval once a year, plus an intake, and those are either conducted or countersigned by a psychiatrist. And that's really what you're looking at, is those intake and maybe the psych treatment notes, if there's anything in them. Usually they're very much like tolerating meds well, right? And that's not super helpful. But you're looking for proof of exposure to actual or threatened death, serious injury or violence, subsequent re-experiencing, which could look like nightmares or flashbacks, avoidance of external reminders of the event, mood or behavior disturbances, and increases in arousal and reactivity. So what you're doing, honestly, is you're requesting and paying for, which DAP, our funding source, will reimburse you for, behavioral health intakes, behavioral health reevaluations, and for all behavioral health providers, and you're reading and you're trying to find references to which you're pin citing and letters that you're writing to Social Security or briefs that basically pull out, was there a trauma? Are there flashbacks or nightmares? Are there signs that look like avoidance? Do they have mood or behavior issues as a result of the trauma? And do they have increases in arousal and reactivity? And this is really hard. It's not hard because people who have trauma diagnoses don't have these things. It's hard because you have to find those perfect sentences in your medical evidence. And so when I say a lot of people don't qualify at the listings, it's because they don't have that perfect sentence in their intake or their re-eval. It's not because their symptoms are not present, right? That's the thing that's tricky about these cases. And then if you can do that, if you can get there or get close to there from the behavioral records, then you get to look at the therapy records, and you get to look at their school records if they're in school. You get to look at like things that their family members say. And then you're looking at whether or not you can show that they have, in general, we're really going for 2 areas of limitation. And those include, you know, how they learn, how they get along with others, how they retain, how they focus, and how they adapt and manage themselves, which can include both emotional regulation and activities of daily living, including money management, bathing, toileting, showering, and bathing and showering are the same thing, but you know what I'm saying, like cooking, all of those things. That's where you're sort of asking a lot of questions that maybe if you've ever done one of these cases or seen people do these cases, you kind of drill down into. That's really, we're getting at the B criteria in those cases. And so to win on a listing, you have to do both, right? Like you have to be able to find that medical evidence in section A of the listing, all of these things in this checklist, and every mental impairment has its set. And then you have to find 2 areas of limitation. You can win on one extreme limitation. It is very unusual. You know, what's the difference between extreme and marked, like whatever the judge says it is, right? Like, so generally we're looking for 2. We're trying to at least make a colorable argument in 2 areas. Sometimes you just can't do it. And sometimes you just, if you're doing a letter brief, which is part of our practice at CLS, you literally just write a letter and you're like, the trauma listings, you know, 12.15 is implicated, and then you just keep it moving because you're not, because again, your client doesn't have trauma, but because their records are crappy, right? Because that happens a lot in our healthcare system sometimes. But this is the work around doing these cases. There's a third way that you can win. So you have to get the A criteria no matter what. If you can't get the B criteria, then you can also look to the C criteria. And what the C criteria is really looking for is basically, are you doing okay now, but would you decompensate if you were not in those situations, if you were not in your present situation? So if you don't leave the house, right? Like your records say you're doing great, you're doing telehealth, everything is fine. But if you had to leave the house and interact with the world, you would seriously decompensate. That's what the C criteria is. I imagine that we don't see a lot of C criteria cases. I've only had a couple over the years, but I think we might see more, because I think we have people who haven't left the house, right, in 18 months, and they haven't been in treatment, and maybe their records reflect some stability, but they haven't gone anywhere, and they haven't had to interact with the outside world. And maybe as the world is coming back, things might look really different for them and for how their impairments interact with their environments. And so that's where you get into the C criteria. I'm not going to belabor it, but for people who really have a very regimented, like maybe you're in therapy 3 times a day, or again, you're not leaving your house, you've totally divorced yourself from whatever stressors are part of daily life. But if those stressors were to come back, you would decompensate. Like if you can come up with some medically documented, right, medical evidence that that's the case, then you can maybe not win using this stuff, but you can win using the C criteria. The case that I won on this, like my first case, was somebody who had a case manager who basically like spent 12 hours a day with them and like took them everywhere, and was basically like they did not interact with the world throughout the lens of their case manager. And our argument was like, yes, like it's great that they're improving, but this is not somebody who's going to be successful in the traditional workforce, because you can't have your case manager like while you're working retail, right? And so that's sort of the conversation that the C criteria brings on. I just read through this in some detail. You know, I said, you know, you can see what's the difference between marked and extreme, the difference between seriously limited functioning and no functioning. It's, I guess you kind of know it when you see it. It's really like how the judge feels in a given day. most people, as I said, don't win at step 3. And if you don't win at step 3, it's not the end of the world, because the vast majority of people win at step 4 or in legal services cases for SSI at step 5. Step 4 and 5 are largely considered together, and it looks at your ability to either return to past relevant work or to perform any work. And SSI, we're really mostly at step 5. I know some of you do SSDI cases or will do SSDI cases. SSI cases, you don't have a lot of work. Maybe you have some work, but you don't have much work. And so it is unlikely that step 4 is too big of an issue. We're really looking for step 5, your ability, and then we're looking at a combination of factors: your age, your education, your past work experience, and then the real work is this piece, this like term of art, residual functional capacity. So residual functional capacity is the most that a person can do despite their physical and mental limitations. So this is, maybe you've heard some of this conversations about like, how much can you walk? How long can you sit? How long can you lift? How long can you carry? There are very technical and very Googleable standards for like how much work you can do based on how long you can sit, stand, walk, which is developed both through your client's testimony and then also through medical records. RFC for mental health cases, which is kind of a little bit of what we're focusing on as a case study, also includes what we call non-exertional limitations. And that is the ability to follow instructions, get along with others, and deal with work changes. And so through both testimony of your client, testimony of other people, testimony of the cross-examination of the vocational expert, which Sarah's going to talk about, that's how we sort of develop whether people are able to join the workforce. Because, if you are in a situation, if there is medical evidence and client testimony that anytime you interact with the public, whether it's on the bus or when you're waiting in line at the welfare office or in a past work experience, you or a family member, you get in a verbal altercation, you are probably not going to have much residual functional capacity, because you're not going to be able to get along with coworkers, supervisors, the public, right? And that's part of like the work world. And so that's really what you're doing, right? Is like you're looking at people's medical records and their testimony and the other evidence that you can find and sort of relating it to work using these technical Social Security standards. Part of this process is one of the things that's really scares people. It's called vocational experts. These are jobs experts that come to hearings. They use another dictionary, not the listings, but something else called the Dictionary of Occupational Titles, which is something that's set up by the U.S. Labor Department. It's super out of date and antiquated. There's like litigation and policy work being done around that. But what happens at the hearing context is that judges ask whether a hypothetical person with the claimant's age, education level, and past work experience and physical and or mental limitations can perform their past work. If they say no, then we ask if they can perform any work. And after the judge poses hypotheticals, right? It's not about your client, it's about a person that looks just like your client. And they're going to pose hypotheticals that take into account all of the evidence that you and your client have presented, right? So if you are in a situation where the hypothetical is cannot get along with anyone, including supervisors or the public, that's probably going to be a no. They can't do any work, right? And so the trick in these cases is to get the judge to the point where the judge asks a hypothetical where you get no jobs as the answer, or for us, as the attorney representatives to ask those questions and to get the vocational examiner to agree that the hypothetical person looks just like your client is unable to work. Past work, anything in the last 15 years, and it has to be that substantial gainful activity. So if they worked $1,200 or $1,300 a month in the past 15 years, that's what we're really worried about. Maybe $1,000, anything over $11,000 if we're going back super far, because that money, that dollar threshold goes up. And so anything less than that, if somebody made $600 12 years ago a month, not substantial gainful activity. We're not worried about step 4. Step 5, we're looking at a test about any work that in the economy, which so feather shaver, I think that's one where you have shaver, where you have to like make stuffed pillows, boxes, kitchen work. Everybody's got their favorite ridiculous job. Any ridiculous possible job, regardless of what, if you're practicing in Lancaster, regardless of how many feather factory, down pillow factories exist in Lancaster, doesn't matter. It's just like, does this job exist somewhere in the US? And that's why people get kind of cranky about this process and why there's so much thinking about how to reform it. The other, if the judge finds that they can work, even if it's not a real job, in as far as like the Lancaster like labor market, at that point, your client loses. And so the goal, as I said, is to really get everyone involved to conclude that your client is not able to work based on the interplay of their medical records, their testimony, and then this sort of made up hypothetical process where we sort of ask if your client can like and get along with people, sit, stand, walk, all of those things. There's something called, sorry, I feel like I'm like totally botching this process. There's something called the grids, which is was just an algorithm. Again, everything in Social Security is Googleable. There's zero like Westlaw involved. It's like all like Google searches for, so you can Google the grids and look at them right now. As people get older, there's algorithms that make it easier for them to qualify. That's sort of the short form. We've done some trainings on this that are in the training bank, and something to just, certainly like we can retrain on these in the future. I'm not going to go too far into it because I see I have a few questions and I want to leave time for Sara. I'm going to pause just now and look at the questions I see. So I see Sara put in the in the thing. That's great. Have we seen claimants determined to be disabled based on with COVID reason? Yes. So this is a great question. This is from Queenette. Yes, Queenette, we have, and a couple months ago, I think, I'm like getting my months, like time has no meaning. I think last month, right? May? Richard Weishaupt from and Sara facilitated a conversation on long COVID that I believe was recorded. And so that was a training on what Social Security is doing, where we think Social Security is going to go in the future, and then like a discussion about like how to practice in these cases. And so I will just sort of refer you to the plan training bank, maybe at the end, Kelly, or you can share any information about how to access that. There's a long discussion, that's very on point, and lots of people are thinking about it, and so we have kind of up-to-date information in the plan training bank on that. Just scrolling down, just check what I said. For the A and C criteria, medical documentation is required, but not for the B criteria. Yes, so Michael, that's right. So while I think for C criteria, there has to be interplay with medical evidence. I think medical evidence is stronger. For B criteria, you do not need medical evidence. That can be therapy records or non-medicalized information. A criteria is absolutely, you cannot meet the A criteria without medical evidence. C criteria includes sort of some mushy medicalized words. I have one C criteria cases on case manager testimony, but it was backed up by psych records, by medical. And so I think that's a sort of the interplay there. And then Sara has linked in the chat. Please do say that. That's the emergency memo on COVID, which I believe includes the liberal good cause. I'm going to pause because I want to have Sara have her like full 30 minutes to talk about practice and turn it over. I'm going to stop showing my screen and let Sara share hers so she can use the slides.
Thanks, Kristen. So I think you can see my the practice tips. Okay, great. Okay, so Great. You might see me looking off to the side. I have two screens, so that's why. So our first practice tip is to develop the record. And so what part of what that means is encouraging your client to get into treatment and stay treatment compliant, because this is ultimately, as Kristen was saying about criteria A and about having the medically determined impairments, this is essentially a medical program, and your case is going to have to be premised on solid medical evidence. There's also a Social Security ruling about failure to follow prescribed treatment. And especially with COVID, a lot of folks have been having trouble accessing treatment. And so if your client has good cause for their reason not to follow prescribed treatment, develop that in the record too. We're also looking for cases where people might have been, sent to a consultative exam or otherwise having difficulties with their case because of inability to access treatment during the pandemic. And so if you have any of those cases, please flag them and send them to us. Developing the record also means requesting records from all potential sources. So starting with the doctors that your client goes to, but also thinking about their school records, records for when they may have been incarcerated, records from third-party sources like family members who help them, or from case managers or therapists. And even if those records are old, especially for youth who are no longer in school, if they have, say, like an intellectual disability, there might be really helpful information in prior school records. So you'll want to get those to better understand your client. And then requesting a medical opinion evidence from treating sources can be vital for your case. Any medical source statement, so that is a statement provided or a questionnaire filled out by your client's treating provider, must be considered by the judge. And so we have different questionnaires that we send, and sometimes I will adapt those for my client's case. For example, I might add some more questions about obesity if that's a factor in my client's case. And so we encourage you to send those to your client's doctors to have them fill out. And at the hearing, we have some recommendations as well. So once you get to the hearing stage, you've developed the record, we would say, oh, sorry, I knew I missed a slide. But before you get to the hearing, I'm going to start with the second bullet point of knowing the medical record and knowing the record cold. So that's going to include not just the medical records, but also your client's work history, because as Kristen mentioned, this is a program that to be eligible, you have to show that your client can't work. So you're going to want to know what kind of work they used to do to show why they can't go back there. Or maybe your client has a bunch of work attempts, and because of their disability, they were not able to work for over a month. That's very strong evidence to show that they can't work because they've tried and they can't. And then we also recommend writing down and knowing the procedural history because the judge might ask that as well. And then you're going to want to research the listings. We put them in the chat. This is an adult SSI training, but I also put the childhood listings in the chat. Or if your client is older, look at the GRIDS rule to see where your client falls in the GRIDS rule. And that might be the theory of your case, that your client is disabled under the GRIDS rule, and then all applicable Social Security rulings. So kind of one of the things that I do is whatever issue I'm facing, I just kind of like Google it. So if I see that my client, for example, had interrupted treatment or tells me that they were prescribed something by their doctor, but they don't want to take these pain medications because they have family members who have been addicted to pain medication before, or some good reason, I might Google like SSA not following treatment, and that's how I actually prior to this found the Social Security ruling 18-3P about failure to follow prescribed treatment. So you can find all of the Social Security rulings just by Googling, and there's a lot of different ones depending on your case. For example, Kristen mentioned fibromyalgia and obesity as being difficult cases. There are Social Security rulings for that. So research them and ask your client questions. So that brings me to the third point of preparing your client to answer questions credibly and thoroughly. Your client is your best expert. They are the expert in their lived experience, and they're going to help you to not just develop the record by saying, well, this person can really explain to you all the help that I need, but also at the hearing, their testimony is going to be front and center. So you want to prepare them to answer difficult questions, or also it's awkward and it's hard and it's often traumatic for clients to talk about their disability. So you're going to want to practice with them. An example I have is I recently represented someone whose main disability was pretty extreme anxiety. And my running theory of the case was that she just could not socialize with others, and she was very isolated and would often have panic attacks when she left the house. And I was very immersed in her psychiatric records and her therapy records, but I had missed in a visit that she went to her primary care doctor that she had mentioned having a boyfriend. And so you're going to want to look through everything, because the judges are going to find that one tiny piece of evidence that might suggest that she's more social than all the other evidence is pointing to. And she did a good job answering it, but it was really, I was remiss not to prepare her to answer that question about, well, if you have so much anxiety, how are you able to maintain a relationship with a significant other? And then consider submitting a short pre-hearing statement. We often do that, where we summarize all of the evidence and present our theory of the case, and then also address things. For example, if somebody has a drug and alcohol addiction or disorder in their records, we'll explain, for example, why that might not be material, because if it is material, they will be found ineligible. So at the hearing, you'll want to have a thorough summary of the medical record. Some judges might ask them, they might say, counsel, you mentioned that your client was diagnosed with X, Y, or Z, and where is that in the record? So it's always helpful not to be caught off guard and to have all of that before you and ready to present. So what I usually do is, when I'm reviewing the records, I just bullet point out the page numbers and the main points, where the diagnosis is. And when we submit our pre-hearing statements, we'll also cite to the record as well. So you can have it in multiple places. Or if there's something very salient about a client's inability to interact with others, I make sure to make that a bullet point and highlight it so that I have it like printed out before me during the hearing. Every judge is going to run their hearings a little bit differently. Some might prefer to start asking the questions themselves to the client, or they might allow you to start. I always prepare an opening statement just in case. And if permitted, you can use that as, a way to frame the case and advance your theory of the case. So you can prepare an opening statement or a closing. And then you can build the record through direct examination. The judge might start out with that. And so what I usually do is I have all the questions that I want to ask. And if the judge touches on it, they might ask the question the same way I did, or they might frame it differently. Either way, I'll cross that out. You don't want to duplicate what the judge has already asked. They like to go through these hearings relatively quickly. They have a lot of cases to hear per week. And so you don't want to duplicate any questions. That's going to give the judge the kind of a bad taste in their mouth. And also you'll have less time to draw out other areas of your theory of the case. And then that brings me to the final point here of building rapport with the ALJ is going to go a long way. They hear a lot of cases, maybe similar to what you're presenting or otherwise, and sometimes they might have compassion fatigue. So you're building rapport with the ALJ can go a long way, and also using your kind of soft skills to humanize your client, and also doing what you can as the attorney. Some folks are not represented, but as the attorney, you can argue the case and perfect the record and fill in where there are gaps. So the vocational expert component of the hearing was, I felt very intimidated by this process when I started, but there are things that you can do to prepare. And as you do more hearings, you'll get more comfortable, of course, with this area. One of the things that we recommend is that you prepare your own hypotheticals based on the record. You can kind of predict in some circumstances what the judge might present to the vocational expert as a hypothetical, and then make your own. So if you sent, for example, a questionnaire to your client's therapist and they came back saying that your client has panic attacks, for example, multiple times a week, you can craft a hypothetical based off of that. And there's some key words that I'm learning are like Social Security speak and vocabulary. For example, and again, all of this is Googleable. Words like frequently and occasionally, those are kind of key words to use. So you might say, assume that the person would be frequently unable to do X, Y, or Z, depending on what their disability, how their disability affects them, either physically or in terms of mental health. Or say this person can only occasionally interact with the public. And you'll want to frame your hypotheticals to whittle down ultimately to no jobs. At the very least, we have some magic questions to ask, and this is so that you can build your case for appeal. One of those is your testimony limited to the parameters identified by the ALJ in the hypothetical? The vocational expert is not supposed to consider anything outside of the hypothetical factors that the judge provides. And so that's a good question to ask to set up the case for appeal. And then in behavioral health cases, first of all, you're going to want to develop your record to demonstrate that your client might be off task. They might be off task because they have auditory hallucinations, that they're hearing things, and so they're going to be distracted by that. Or they might be absent multiple times a month because of depression. And as long as you are able to develop in the record that is their experience, maybe a family member talks about them isolating in the room multiple times a month, and that is also echoed in therapy records and by the client's own testimony, then you have a basis to ask a question of how many absences in a month are permissible to maintain competitive employment. And if the answer is, they can't be absent through more than 3 times a month, then you're building your case up to show that your client wouldn't be able to sustain employment. And the question is not whether your client can work one day for 8 hours, just one day. It's whether they can sustain that employment full time. And finally, if the vocational expert does find jobs from the dictionary of occupational titles, whether that's like feather shaper or whatever, there will be a code that goes with that job. So make sure to jot down that code. You can look it up in real time, or you can look it up after. Jot down the DOT codes that are cited and check afterwards that they are indeed what the vocational expert said they were. And that way you can kind of set up the case for appeal as well. There's a ruling, the all evidence rule, that I was prior to this, I was kind of looking these up, and The all evidence rule, we have the source cited at the bottom of this slide, but it's also, and another slide will cite to this, there's also Social Security ruling 17-4P that talks about this. It says that representatives have to submit all of the evidence that they have or inform the judge that they might be aware of that relates to the disability claim. So if you receive records from your client's psychiatrist, for example, that say ever since starting on whatever regimen, Mr. Jones is doing great, very functional, no more symptoms, you have to submit that even though it's might be a big blow to your case. And this also includes non-medical evidence, so school records or criminal records. So once you get that evidence, you turn it in. And what I do is as soon as I get it, I make sure that, you know, if I receive it via fax and my request is in there, I take out my request and I submit whatever is the relevant actual evidence. The duty to submit all of this evidence includes duplicates unless it's the exact same evidence. So you don't want to send in records that are already exhibited. So make sure you're checking to see what Social Security already has in the file. And if you get the same exact thing, you don't have to turn that in. But sometimes you might get more evidence than Social Security was able to obtain. So you want to make sure that you're sending in what you have, even if it's for the same source that's already in the record. If there's anything new, you want to send that in as well. There's also a 5-day rule in which you have to submit all of your evidence within 5 business days before the hearing. Otherwise, the judge does not have to consider it. To make sure that all of your evidence is considered, you want to send it in 5 days before or inform the judge that you have made a request for these records, tell them about your efforts to obtain that evidence. And if you haven't gotten it, inform them that this should be a part of the record 5 business days before the hearing. We also submit, as Kristen mentioned, pre-hearing statements framing the case and advancing our theory of the case, and that must be submitted 5 business days before the hearing as well for the judge to consider. And the 5-day rule does not apply in continuing disability reviews and age 18 redeterminations. So what we do at CLS is we often send a reminder for that. So we might send in, we have inform letters that are template letters we send to the judge that says, we under the rule, we're sending you all of this evidence we're aware of from these providers. But for CDRs in age 18, we might send that letter, but also send a reminder that it's not required, but we're sending it for their convenience. We send these inform letters as part of our duty to inform. We have an affirmative duty to submit or inform Social Security about written evidence. You have a duty to develop the record too, to develop the written evidence. So that means that you will need to help your client get the medical records and help Social Security get the medical records that are relevant and other records too that are relevant to their disability claim. You can't wait until 5 business days to kind of dump all the evidence onto the judge. So to ensure that we are keeping up with the right timeline, we set reminders to send in inform letters about the evidence. We typically do it 35 days before, then 10, and then 5. What I do is as the evidence comes in from the providers, I make sure that it's not a duplicate and that my attorney work product is not included, and then I send it in immediately. This is a repeat. Okay. You also have a duty to inform Social Security about when you asked a doctor or a provider or for medical opinion evidence. And so you can put that into your inform letter as a way to ensure that you're informing the judge about this. And you can also tell them at the hearing. But that is part of the regulations. And these regulations were updated in 2018 to ensure that representatives were being ethical and conscientious and disclosing when they were soliciting medical opinion evidence. You have, and this obligation includes whatever medical opinion evidence you had a role in preparing. And so that might be, you know, maybe your firm, like CLS, has a template version of a questionnaire to send to a doctor. So you might not have told the doctor anything to put in there. You might not even had a conversation, but you sent them that questionnaire and you prepared the template. So you have a duty to notify Social Security that you solicited that opinion. The rules also say that you cannot withdraw as counsel after the hearing is scheduled unless there are extraordinary circumstances. So once you are on as the representative and that hearing is scheduled, you are representing. Extraordinary circumstances include if there is serious illness or death in the family or serious illness in your immediate family, or failure to locate the person you're representing despite your active and diligent efforts. And this last point, our clients live very difficult lives. A lot of people are transient. Sometimes, even despite all of your efforts to maintain in touch, you might lose touch. So I recommend just documenting that and being present at the hearing, even if you haven't heard from your client, but definitely document your efforts to locate them. There's also an obligation to send in your availability for scheduling. There's a centralized scheduling program and email. So Pennsylvania has moved to centralized scheduling rather than having the individual Office of Hearing Operations do their own scheduling. So you will just email, and it's actually not by the 5th of each month. I think it's on the 20th of each month. And Kristen can correct me if I'm wrong, but you'll just email your availability. Yeah, it's the 20th of each month. We can fix this. You can email that to the centralized scheduling email, and we'll fix this when we send it out, or you'll have this email when we send it out. And you have to give in your availability 3 months in advance. You might not know, something might come up after you send in your availability. It has to be accurate at the time that you're sending it, but then you can go in and periodically update it. What I do and what the other attorneys at CLS do is on the 20th, we put in a reminder every 20th of the month to send in that email. We have a template email that we just update for the next 3 months in advance and send that out. And if it's on a weekend, I'll do it before, on the Friday before.
Sarah,
So
if I could just.
Yes, go ahead. Yeah, go ahead.
This is Kelly. I need to launch the second of the CLE poll boxes. Attorneys, you must respond to this to receive CLE credit. I will leave this up for 2 minutes, and Sarah, please continue. Thank you.
Thanks. Okay. Yes. Okay. So while you're filling out the poll, if anyone has any questions, now is the time to ask. You can put it in the chat box or you can unmute. Okay, well, I will just say that some of just to summarize some of the recommendations that we have is one, remember, as you all know, because you do direct client work, is your client is the best expert. They will help you develop the record. They will tell you who to talk to. Maybe there's a former employer who can talk about all the accommodations that they tried to give them, but ultimately the job didn't work out. You can submit, and we recommend that you submit an informed letter informing the judge about all the evidence you're aware of that relates to the disability and any medical opinion evidence that you've solicited. We recommend creating questionnaires to solicit those medical opinion evidence. Like Kristen said, sometimes it's hard to find that exact perfect symptom for criteria A. So if you send a doctor a questionnaire with all the symptoms listed out, you might be able to get that into the record where it otherwise would be harder to find. And we recommend that you submit a pre-hearing statement. And if you cannot get evidence, you can request that the judge subpoena the evidence. And you can do that by writing to the judge and explaining the basis for the subpoena. I think that there's guidance on this. Again, the beauty of this practice is everything in Social Security is kind of like Googleable. And so I don't have that citation now, but you can ask the judge to subpoena that evidence. Sometimes there are providers where it's a bit more difficult to get the evidence than others. So thank you for that reminder to my colleague Jonathan about subpoenaing for evidence. And so I think if we don't have any other questions, and if Kristen, you don't have anything to add or correct, that's it for me.
No, not at all. I only want to just make a plug that you join us. So we are meeting every month, the last Thursday. So if this is your first time joining us, welcome. We would love to see you next month, July. I think it's going to be a really special presentation. Some of the law students across the state are going to be presenting a docket on recent and noteworthy Social Security decisions that will guide our practice, and also just be like really exciting for those of us who don't often get to think big picture, to kind of get to kind of delve into some of the interesting cutting edge law that's been created around Social Security. And so please join us if for no other reason than to cheer on our future practitioners from our law students internship programs from across the state. And then we'll be pausing. I think we'll be skipping in August because we're anticipating lots of people will be away. And then in the fall, we're going to do a series around medical evidence. Best practices. We're going to do a refresher on some of the ethics around getting and submitting evidence. So we'll have an ethics session. If you need ethics credit, please join us for that, if nothing else. And then also please join us for some conversations about best practices around evidence, what judges look for, lots of other kind of things that I know from our surveys people are excited to delve into. So stay tuned for those from Kelly after Labor Day. But please do plan to join us in July to cheer on our law student interns. And thank you all so much for being here.
Thanks, Kristen. Thanks, Sarah. Everybody have a good rest of the day. Take care.
Thank you. Bye.